Morning. Welcome to today's program titled Vaccine Mandates, Proof of Vaccination, and Other Return to Work Updates in New York. At this time, all participants are in a listen-only mode. For those of you who are logged into the web presentation, you are encouraged to submit throughout the conference by typing them into the Q&A box on the right-hand side of your screen. For those interested in obtaining CLE credit today, an attendance verification code will be read during the presentation that will be required for CLE attendance. Please write down this code as it will not be reread and it will be required on the CLE verification form sent to you following the program. Copies of the webinar recording and materials along with the CLE form will be sent to you in the days following the program. At this time, I would like to turn it over to Bob Nobile, who will be our first speaker. Bob, you can start from here.
Thank you, Morgan. Good morning, everyone, and welcome to our webinar this morning. My name is Bob Nobile. I am a partner here in the New York office of Seyfarth Shaw. Pleased to be with you this morning, along with my colleagues from New York, Ann Dana, Meredith Berger, and Dan Small. And we are going to talk about several issues this morning. First of all, the issue of whether employers can mandate vaccinations of employees. We're going to look at proof of vaccinations, as Morgan mentioned. Meredith is going to look at sick leave issues, and then Dan is going to talk about a new law recently enacted in New York called the HEROES Act. So with that, Morgan, can you advance to the next slide, please? Next. One more. Good deal. Many issues arise with respect to the subject of whether an employer can mandate employees to be vaccinated. The threshold issue, however, for employers is, do you really need to mandate vaccinations? And we're going to talk about some of the legal implications here. But first, I want to mention a famous statement that was made by Shakespeare when Hamlet was circulating back in literally 1609, when he made the famous statement, to be or not to be, that is the question. Who knew at that time that Hamlet was actually talking about vaccinations? Only kidding, folks. So let's move into more serious territory here. The first issue being the Equal Employment Opportunity Commission. As most of you know, the EEOC is the federal agency that enforces a number of laws, but the two of most significance that implicate vaccinations, actually there are three, the Americans with Disabilities Act, Title VII of the Civil Rights Act, and GINA, the Genetic Information Non-Discrimination Act. And the EEOC has published guidance late last year on whether vaccinations are permissible. And the EEOC has taken a position that if employees receive the vaccination from an independent third party, that a vaccination would in fact be permissible. However, the EEOC also goes on to state that if the vaccination is administered by the employer itself, the employer must establish business necessity for the vaccination due to the fact that there will be some pre-screening questions that will be associated with the vaccination process. And they could be considered disability-related inquiries under the ADA. And in that instance, the employer must show that the screening is job-related and consistent with business necessity. That is, employees not vaccinated will pose a direct threat to the safety and health of others in the workplace. Frankly, it's our position that in this day and age, with all of the precautions that employers are able to take, that's going to be a difficult burden for many employers to meet. Next slide, please. Back to my Latin days from high school. Sit vaccinator cave, let the vaccinator beware. While the EEOC, on the one hand, indicates that vaccinations are permissible, there is a law out there, the Food, Drug, and Cosmetic Act, that effectively states that individuals can refuse the vaccine because vaccines, as of now, have only been approved for emergency use under the Act. And frankly, the emergency use authorization has given rise to several lawsuits that are currently pending in California, New Mexico, and Pennsylvania. And just to illustrate the nature of the lawsuits, the plaintiff in the case in New Mexico effectively has stated that the applicable statute, that's the Food, Drug, and Cosmetic Act, states that individuals to whom such vaccines are administered must be informed of the known and potential benefits and risks of its use and of the option to accept or refuse administration of the vaccine. So under the FDCA, individuals would have the right and should have the option to refuse administration of the vaccine. So that's directly contradictory to what the EEOC is saying. Arguably, there's a question then in the minds of many lawyers as to whether or not vaccines can be mandated. And this could be one of the reasons, ladies and gentlemen, why at the current time, based on a number of informal surveys that I've read, less than 5% of employers out there are actually mandating vaccines for their employees, and only an additional 5% said that they will mandate should the FDA give full approval to the use of these vaccinations. And I'm sure many of you know that on May 10th, Pfizer and its European counterpart BioNTech applied for approval, full FDA approval for use of its vaccine. But on the other hand, based on historical data, researchers at Yale University and Duke University have indicated that the full FDA approval process in the past has taken an average of about 12 months. Now, it remains to be seen under the Biden administration, which, as we all know, is really in full support of individuals becoming vaccination, whether they will nudge the FDA to see if they can push the approval process a little further down the road. Next slide, please, Morgan. In addition to the EEOC's position and the FDCA, employers must also consider the fact that there is a plethora of legislation that has been introduced around the country. There are probably over 30 bills now that are pending, and many of these bills have passed would either prohibit employers from requiring vaccinations, prohibit adverse action against applicants and employees for refusing to be vaccinated, and prohibit adverse action based on vaccination status. And what I've included here is just an illustrative list of some of the major jurisdictions that have bills pending. Now, the legislative sessions in many of these states are quickly coming to an end for this year, so we don't know how many, if any, of them will be passed, but it's good to know that the legislation is out there. In addition, we also have 7 executive orders that have been signed by various governors. You can see the list there: Arizona, Florida, Idaho, Montana, South Carolina, Texas, and South Dakota. They've all issued executive orders prohibiting vaccine passports and requirements, and Ann is going to talk about the passport process shortly, so I'm not going to go into that. But the reality is most of these executive orders prohibit state and local governments from requiring citizens to provide COVID-19 vaccination status to receive services or enter certain areas. Next slide, Morgan, please. So the issue is back to whether or not an employer should mandate a vaccination, or whether, frankly, it makes sense for employers to wait until one of these vaccines is fully approved by the FDA before deciding on a mandate. Now, if in fact you do decide to mandate, there are a couple of issues you have to consider. Number one, we mentioned already that you should consider using an independent third party so that you don't run into the issue of being accused of making medical or disability-related inquiries. And then the all-important issue is that if an employee cannot get vaccinated because they have a qualifying disability or a religious objection, they may be entitled to an accommodation. The disability, of course, under the ADA, and the religious accommodation under Title VII of the Civil Rights Act. And again, the issue for the employer is going to be determining if someone has a disability or requests a accommodation under Title VII, whether the unvaccinated person exposes others to virus in the workplace that cannot be excluded, even if a direct threat. unless there is no reasonable accommodation available that would eliminate or reduce the risk of unvaccinated employees no longer posing a threat in the workplace. Next slide. There are a number of conditions for which accommodations may be requested by employees. First of all, there have been a lot of questions from employers about whether or not an employee who has a fear of being vaccinated is disabled under the ADA, and the answer is no. Fear of vaccination is not a disability. However, anxiety may be. There are some people who are legitimately so afraid, deathly afraid of going out, of mixing with the public, that their anxiety may in fact create a covered disability under the Americans with Disabilities Act. There are some people who have allergies. I mean, I can speak from experience. My own daughter, my youngest daughter, has had adverse reactions to the regular flu shot, and she was instructed by her treating physicians not to get vaccinated. And that, of course, has created an issue for her because she's a speech therapist and deals directly with school-age children. There are other people with autoimmune disorders who legitimately cannot obtain the vaccination. So if an individual steps forward and says that they have a disability and they cannot be vaccinated, then the employer is going to be required to follow the standard Americans with Disabilities Act process, and that means engaging in an interactive assessment or an individualized assessment with the employee and his or her healthcare provider to determine whether the nature of the disability precludes them from coming into the workplace, whether they even have a disability, and what accommodations can be made. And obviously, the employer has the right to look at supporting medical documentation. We clearly recommend that employers don't simply jump to the conclusion that the employee can be terminated. That could give rise to an ADA claim. Next slide, please, Morgan. Accommodations that employers can make, and many of you are doing this now, even in the absence of accommodations, masks and face coverings or other personal protective equipment. Testing measures can be invoked. Social distancing in the workplace, remote work if that's feasible, alternative work hours for employees that will give them perhaps an off shift where they have less exposure to other employees, perhaps giving an unpaid leave of absence, and Meredith is going to talk about that, or a combination of some of these accommodations. So there are accommodations out there that can be made. So termination may simply not be a viable alternative for most employers. Next slide, please, Morgan. Let's look for a moment at the religious discrimination issue. If someone comes forward and indicates that they need an accommodation based on their religious beliefs, first of all, obviously, the employee has the duty to request the accommodation. They must have a sincerely held religious belief that precludes vaccination. The EEOC, by the way, in the past has taken a position that employers generally should not question religious beliefs. And note in this regard that being an anti-vaxxer is not a religious belief. Now, does an employer have any, frankly, rights in these areas? The answer is yes. If the employer has an objective reason for believing that the request may not be based on a sincere religious belief, the employer can certainly ask for documentation, engage in the interactive assessment with the employee, and frankly, then make a determination whether or not an accommodation can be granted. Now, bear in mind, under Title VII and under the ADA, the burden is on the employer to demonstrate undue hardship. Next slide, please, Morgan. So that brings us really to the position where the rubber meets the road, and that is, what exactly are employers going to do? Most of you are gearing up to bring your employees back to work, some on a full-time basis, some on a part-time basis, some will be doing a hybrid work from home and in-office shifts. So issue number one is, do we mandate vaccinations, or frankly, do we make vaccinations voluntary? So regardless of whether it's mandated or voluntary, what kind of proof are you going to require from your employees? And again, Ann's going to address this, so I'm just raising the issue at this point in time. What kind of proof will you require? And more important issue is, how are you going to distinguish in the workplace from those who are vaccinated and those who aren't? And there are a lot of employers now grappling with that particular issue. Do we abide by the honor system and have employees tell us, yes, I've been vaccinated, therefore in the workplace they don't have to wear a mask? Do we require employees to wear some kind of bracelet to identify themselves as vaccinated? My biggest concern there is it sets up what I call the scarlet letter syndrome. You got people walking around with bracelets, those who haven't. It could be a basis for your workforce, quite frankly, becoming polarized. But these are serious issues that you must grapple with as employers as you bring your employees back to work. The next slide, please, Morgan. Okay, last slide and points that I want to make. Other vaccination and disability-related issues. The issue of pregnancy. I've been getting many calls from clients about they have employees who are pregnant. They are afraid to go out. They are afraid to come back to work. There are people who have said they are planning to start a family and are concerned about what the vaccination may do, to their health. And frankly, the CDC has taken the position, if you wish to abide by the CDC and use that as your Bible these days, CDC has published that there is no evidence that a COVID-19 vaccination causes any problems with pregnancy, including development of the placenta, does not affect individuals who are currently pregnant or those who are intending to get pregnant, and also no evidence that it will cause infertility problems. CDC has also stated that there is no evidence that vaccinations alter or interact with DNA in any way. So with that, I am going to turn the presentation over to Ann Dana, who's going to talk about proof of vaccinations and current New York City or New York State guidance in this regard. Take it away, Ann.
Thanks, Bob. So I'm going to discuss mandating proof of vaccination and the current New York COVID guidance. With vaccinations becoming widely available here in the U.S., numerous states and localities are rolling back COVID-19 restrictions, such as capacity limitations and mask mandates. And one of the most common questions that we've been getting right now after, can employers mandate vaccines for their employees, which Bob just covered, is whether employers can ask for proof of vaccination. So I'm going to talk about New York specifically on the next few slides, but it's important to also be aware of what's happening nationally, particularly when trying to create a single policy across various locations in the United States. So at the federal level, the Biden administration has indicated that it does not intend to implement a COVID passport or a vaccination database. Rather, it's leaving that up to the states and private businesses. And up until recently, the general conclusion from lawyers was that employers could require employees to provide proof of vaccination, and businesses could require patrons or customers to provide proof of vaccination with the obvious caveat, of course, that they may need to do an accommodation analysis when required, as Bob kind of just went through. However, as we saw with mask mandates, the concept of COVID-19 passports or health passes or other documents to provide proof of one's vaccination status are becoming a bit of a political lightning rod here in the U.S. So where states like New York have viewed such documentation as a viable tool for promoting safe in-person interactions, which has been demonstrated by New York being the first state to roll out kind of a state-issued COVID passport, which is called Excelsior Pass, other states have viewed such documents as an affront to privacy and individual liberties. As a result, we've seen the enactment of numerous executive orders and the introduction of proposed legislation, typically tends to be in red states, that are implementing a variety of prohibitions against providing proof of vaccination. We don't have time to go through each of the states today and during the presentation, but at a high level, we're seeing the following trends. The executive orders that have been enacted typically ban states and local governments from requiring proof of vaccination to gain entry to stores, entertainment venues, and other public settings, but they do not prohibit private businesses from opting to do so. However, of course, there's an exception. Florida went further and passed an executive order that does prohibit private businesses from requiring patrons or customers to provide any documentation certifying COVID-19 vaccination to gain entry, access, or service from the business. While legal commentators are all kind of agree that they're expecting legal challenges to this, particularly from the cruise ship industry, which was hard hit during the pandemic and really saw COVID passports as the way to return to business. Businesses operating in Florida right now should be aware of this and be aware that that these types of laws are out there and may, be increasingly passed. A few states have gone ahead and proposed legislation that would, if passed, clearly prohibit employers from asking or requiring employees to provide proof of vaccination. The last time I checked, which was a couple of days ago, none of the legislation had actually passed. That said, I do want to have a caveat that there's some executive orders that, as written, aren't entirely clear. Arkansas is one of them. Our interpretation is that it probably doesn't prohibit employers from asking employees for proof of vaccination, but that's kind of a to be determined determination. And then the flip side of this is that just recently we've actually seen a few places, Santa Clara, California, and Oregon, where employers are required to see actual proof of vaccination to lift certain COVID restrictions like mask mandates. Therefore, employers and businesses who are operating, in multiple jurisdictions are going to need to conduct an individualized assessment when it comes to whether or not to require proof of vaccination, and if so, from whom. So Morgan, we can go to the next slide. So turning to whether employers can mandate proof of vaccination in New York. In New York, employers can ask for proof of vaccination, and that can be voluntary, a voluntary request to employees, or it can be a mandatory policy. The EEOC has made clear that proof of vaccination is not a disability-related inquiry because there's numerous reasons that someone might not be vaccinated. The type of proof that you can ask for can include CDC vaccination cards, proof of a medical appointment to get the vaccine, Excelsior Pass, or other digital health passes. We're aware that there's a number of private industries and organizations that are in the process of creating these kinds of health passes. Or New York just recently came out and said that self-reporting of vaccination status, e.g. the honor system, is also acceptable. If you are requiring or asking employees to submit proof of vaccination, we recommend that you remind employees that when they're submitting that proof, they should not provide private medical information. And then also, we want to note that that these rules can apply to employees, independent contractors, visitors, and customers. So when deciding who you're going to request this information from, you need to decide who you're going to ask for that information from. And then obviously you need to ensure that you are compliant with the ADA, the New York State Human Rights Law, and the New York City Human Rights Law as well. We just want to add a reminder that the New York State Human Rights Law applies to independent contractors, vendors, consultants, and others providing services pursuant to contracts in the workplace. Therefore, any requests for accommodation need to be made available to those individuals as well. We quickly wanted to highlight some of the benefits to asking for documentation. One of the benefits is obviously mask mandates. We're going to get into New York's recent mask mandate on the next slide, but by requiring proof of vaccination, you enable employees or customers to remove masks in the workplace and no longer comply with social distancing. In New York, those who are fully vaccinated do not need to quarantine if they have close contact with someone diagnosed with or exhibiting symptoms of COVID-19. So, and those who are not vaccinated still need to quarantine for 10 days, triggering the need for those employees to take leave, which my colleague Meredith will address during her section. But, you know, having proof, if you're an employer, having proof of vaccination allows you to quickly determine whether or not someone needs to leave the office if there's been an exposure, or determine whether or not somebody needs to quarantine and is entitled to that leave. And then obviously, you know, one of the last benefits that we talk about frequently is the issue of assuring employees and or, you know, customers and patrons of their safety. For example, you know, an employer may want to be able to represent to employees when encouraging them to come back to the workplace, you know, 100% of our workforce is vaccinated, or, you know, you may want to be able to assure, you know, clients or customers that everyone who is in a client-facing role has been vaccinated in order to ensure that those people feel safe. I saw late last night an article analyzing whether or not those who are vaccinated are getting out into, you know, stimulating the economy, getting out into businesses, and the conclusion was that really it's people who are unvaccinated in areas who are going out and you know, going to movies and other, you know, large group events. So there's still, you know, there's still people who are concerned, even those who are vaccinated, who aren't necessarily going out in the same numbers that they might if they were assured of their safety. Morgan, we can go on to the next slide. So as everyone is likely now aware, last week New York announced it is adopting the CDC's mask guidance, which went into, well, New York's adoption of it went into effect on May 19th. The rule here in New York is now that fully vaccinated individuals do not need to wear masks or be socially distanced, but unvaccinated individuals must continue to wear masks and be socially distanced in most settings. And this applies, the state made clear that it applies in most commercial settings, such as retail, food services, offices, gyms, amusement and entertainment venues, hair salons, and barbershops and other personal care settings. Where it does not apply is schools, you know, pre-K through 12, public transit, homeless shelters, correctional facilities, nursing homes, and healthcare settings. The New York guidance made very clear that businesses and employers can still require masks and 6 feet of social distancing for employees or patrons. And it also noted that the Department of Health strongly recommends masks and 6 feet of social distancing in indoor settings where vaccination status of individuals is unknown. And this, of course, gets into kind of some of the questions that employers, that we've been hearing from a lot of employers that Bob touched on is, you know, if you are, you know, what policy do you want? Do you want actual proof of vaccination, or are you going to utilize the honor system? Then on the next slide, we see New York put together kind of a handy 2-page summary of the rules with a useful flow chart. We've summarized the rules on this slide. There's a little bit of difference in New York if you are a business operating below the state social gathering limit of 250 people indoors or 500 people outdoors. And then if you are a business operating above the social gathering limit, which is, you know, event venues, sports arenas, performing arts and entertainment, catering, convention centers, etc. So it's important to be aware, if you fall into this guidance, you should be aware of kind of the differences between what is required, namely that in these larger venues, you need to have designated assigned sections where the vaccinated and unvaccinated will be separated. Note that as of right now, New York is still requiring compliance with the various forms of industry guidance that the state put out, you know, way back when we were dealing with kind of reopening businesses, and that industry guidance does still require a daily health screening. I will note that guidance has not been updated to account for a number of the more recent changes, so it's important to kind of have an understanding of which portions of that guidance still apply and which portions have been rolled back by Cuomo's more recent updates. And then obviously, very quickly, I just wanted to highlight that, New York and the tri-state area, I guess, Connecticut and New Jersey, have really been trying to implement some changes in tandem with one another. Connecticut's Governor Lamont has indicated that he will also, conform the state's requirements to follow the CDC's mask guidance for vaccinated people. And he clarified that the state would be relying on the honor system to confirm vaccinations. Connecticut has not issued its own version of, New York's Excelsior Pass. And then late yesterday, New Jersey issued revised guidance via EO 242, which goes into effect Friday, May 28th. I did not have a chance to review all 14 pages of it before this presentation, but a high-level debrief that I received from one of my fellow associates in this office is that there's no requirement to wear masks or socially distance, whether or not an individual is vaccinated or unvaccinated, in indoor public spaces like restaurants, bars, gyms, salons, etc. Although the New Jersey guidance does say that those who are unvaccinated should still wear a mask. And obviously it allows businesses to implement more rigorous requirements. They just don't have to. However, indoor spaces with no public component, arguably, we interpret this as offices, warehouses, places where you don't have customers coming in or that aren't accessible to the public, are required to still follow the spacing and mask requirements consistent with the CDC requirements. So that means, for the unvaccinated, they still need to wear masks and they need to have that 6 feet of social distance. For the unvaccinated, they no longer need to wear masks and can do away with that 6 feet of social distances. And then New Jersey's also carved out, just like New York, certain spaces where those rules are going to apply, point blank. So child care centers, youth summer camps, schools, healthcare, and senior facilities. And then I think, the thing to note, we've been getting a lot of questions from clients about, what does this mean? Are we allowed to implement two different policies for the vaccinated and unvaccinated? Here in New York, and New Jersey and Connecticut, it's very clear based on the guidance issued by the states that you can have, when it comes to masking, two different policies. Obviously, as Bob mentioned during his section, though, there are issues with, how you're going to monitor the rules, how you're going to ensure, there isn't this drop in morale as employees, feel self-conscious about still having to wear masks because it indicates that they're unvaccinated, et cetera. So a lot of employers are still grappling with these questions and how to implement them in the workplace. So next, I'm going to turn this over to Meredith, who is going to talk about sick leave updates.
Thank you, Anne, for that really thorough and robust update of things that are changing on a daily basis. We try to keep up, but I'm going to give a little overview of sick leave issues before we get to some of the specifics which have to do with COVID and vaccine-related leave. I do want to point out to everyone, you all are probably aware of this already, but New York State has passed its own sick leave law, which expands the amount of sick leave for employers with 100 or more employees to 56 hours. And of course, for those employers who have employees outside of New York City that were not previously providing sick leave, it is a brand new requirement for you all. And for smaller employers, they are still at the 40-hour limit that was previously under the New York City Earned Sick Time Act. Some of the highlights for New York State. Before we get to this, I don't want to confuse anyone. Could you just go back to the title slide, please, Morgan? Thank you. Just some of the high-level important things to note between what's new in the New York State sick leave law. There is no waiting period. As I mentioned, there is an increase in the amount of leave available for some employers. There is no accrual cap. Well, there is an accrual cap. However, there is no cap on carryover, which is a very odd circumstance that the way the law has drafted has resulted in. That makes it incredibly confusing for employers to manage administratively. And also want to note that there is no longer the 80-hour minimum requirement for employees to become eligible, which was previously under the New York City Earned Sick Time Act. Now we can go to the next slide, please, Morgan. To delve into here the New York State COVID sick leave law, which was passed back in last April of 2020 at really the height of the pandemic. This law allows employees to take either 5 or up to 14 calendar days of sick leave, depending on the size of the employer, for reasons relating to COVID in connection with an order of quarantine or isolation. And as you see here, it's a sort of stacked, excuse me, it's a stacked amount of leave depending on how many employees an employer has. And then for smaller employers and for those with 10 or fewer employees or under 100 employees, after exhausting the 5 days or the unpaid leave, employees are eligible for paid family leave and disability benefits, which is an enhanced amount of paid PFL and disability that previously was not available to employees and really is not available for any other reason except for COVID. For large employers, employees are entitled to 14 days of paid sick leave, and there are no enhanced PFL benefits available for those employees because the 14-day calendar period is contemplated to cover the entire quarantine period. There's some uncertainty with respect to care of a child who's subject to a quarantine order. However, with PFL, that really is left up to the carrier. So if your employees do decide to apply for benefits under those circumstances, the carrier would be the one to approve or deny that leave, leaving it outside the hands of the employer, which is kind of a nice, takes the pressure off. We can go to the next slide, please. In January of this year, the State Department of Labor issued some guidance which clarified some of the previous uncertainties and also instituted a multiple order cap of 3 instances of New York COVID PSL under certain circumstances. And this is only where the employee continues to test positive after being diagnosed with COVID-19. So if the employee is initially diagnosed with COVID-19, is subject to an order, or as the next bullet point says, has a positive test with a doctor's note, or if the employer administers the test themselves, there's no need for proof to provide to the employer. Then under those circumstances, if the employee continues to test positive, they can then take up to 3 instances of New York State COVID PSL. So depending on how many days the employee works, if assuming they work a 5-day work week for a large employer, they could get up to 30 working days of leave. But those are, as I said, under those certain circumstances. It's very fact specific, and you should take a look at that guidance to understand whether it would apply. Importantly, this guidance also clarified that if an employer sends an employee home due to exposure or developing symptoms in the workplace or some other circumstance that requires an immediate reaction where the employee needs to be sent home immediately, this new guidance mandates paid leave for that time that the employer is mandating that the employee stay out. So, query whether this creates a new bucket of leave that's separate from even New York State paid sick leave or not. It's unclear. Taking the most conservative tact, if the employee was out for, let's say, half a day until they got a COVID test and were diagnosed with COVID, it makes sense just to provide that employee with the half day of leave, and then after that, New York State COVID PSL would pick it up upon being diagnosed and therefore becoming eligible for COVID PSL. We can go to the next slide, please. As I mentioned before, there is enhanced PFL, paid family leave, in New York for COVID-19 reasons. This is a new, this is an amendment to the law, as I said, back in April of 2020, which requires that the employee is subject to a mandatory or precautionary order of quarantine or isolation. Again, this decision is really up to the carrier. The sort of type of proof that's provided in order to get the enhanced PFL is left out of the hands of the employer for the most part. And as I previewed before, there was an expansion of PFL for a minor dependent child of the employee who is subject to an order of quarantine. And again, this would be sort of punted to the carrier of your PFL. And these reasons for expanded PFL likely do not apply to those large employers of 100 or more, so just keep that in mind. Those employees would, in theory, get enough paid sick leave under the COVID New York paid sick leave law to carry them through the period of illness. Otherwise, they could then become eligible for disability, short-term disability, FMLA, and the like, depending on sort of how big of an employer you are and what the circumstances are. And go to the next slide, please. And piggybacking off the robust discussion of vaccinations, it's a really hot topic. New York passed a paid vaccine leave law, which became effective on March 12th, and guidance then later confirmed it is not retroactively effective, although you could retroactively provide such leave to your employees if you so chose, and the law will sunset December of next year, assuming that hopefully the majority of our population will be vaccinated by then, although it is unclear what effect, if any, a potential booster will have on this law and whether employees will be entitled to leave for those. In the way the law is written, it is broad enough that you could, an employee could be eligible for vaccine leave in connection with a booster if given before the sunset date. So it remains to be seen, whether we'll get clarifying guidance on that. Obviously, there's a lot of medically, there's a lot of uncertainty there as to whether and when a booster will be needed. So we'll keep an eye out for that. And this provides, as many of you probably already know, a paid leave of absence for a period of time away from work, not to exceed 4 hours per vaccine injection to be vaccinated for COVID. So for those of us getting the Pfizer or the Moderna vaccine, an employee could, in theory, get up to 8 hours. If you're just getting the Johnson & Johnson one and done, then you would only be eligible for 4 hours per vaccine injection. And this is time away from work. So if an employee is getting vaccinated on the weekend and they're not scheduled to work on the weekend, they wouldn't necessarily be entitled to this leave. employees must be paid their regular rate of pay, and this is in addition to any other buckets of paid leave that the employee is entitled to. So PTO or sick leave, this is something extra. Like many of these laws, it prohibits discrimination or retaliation, and there's also still some uncertainty as to what notice and documentation requirements are permissible, since the law is really unclear as to what that means. And the guidance that was released so far doesn't shed much light on that either. You could ask for a vaccine card, that's permissible, or something similar. An appointment confirmation might also work, or you could just use the honor system. One thing I did want to note is that this vaccine leave law does not provide time off for any adverse reactions to the vaccine. That would be picked up by paid sick leave, or perhaps if you have a PTO policy that's in place already, or potentially another bucket of leave that the employee is entitled to. So the 4 hours is really, the up to 4 hours is meant to provide leave for the employee to get the vaccine, and not to necessarily recover from that vaccination. So with that, I will turn it over to Daniel Small, who's going to be talking a lot about this New York HERO Act, which is another extremely hot topic these days. Thank you so much.
All right, thank you, Meredith, and good morning, everyone. Thank you again for joining us. So as Meredith said, I'm going to be discussing the New York HERO Act, which is a first of its kind in the nation, very unique law. And what I'd like to go through today is what the law says as of today, where we stand in the legislative process, and then number 3, what proposed amendments might do to change the law. So again, we're going to sort of keep that in mind as we move through the material. I'm going to go through in detail what it says right now. Keep in mind that there's a strong chance that will be changing at some point. It has not changed yet, though. And what that means is that there are operative dates, effective dates for the law as it stands, and until and unless those changes are formally adopted, those effective dates are in effect. So we need to keep in mind what the law currently says, and then what direction the law might likely will be, but not guaranteed, will be heading towards. So that's sort of the summary you see right here. Staying on this slide for just a moment, the 3 main components I want to talk about with respect to the New York HERO Act are, number 1, these airborne disease prevention safety protocols. Number 2 will be these workplace safety committees, which if they sound a little bit union-esque to you, that's true, they do sound that way. And then number 3 are any legal risk or liability risks that come out from these laws, that the laws provide for. So Morgan, if you don't mind, the next slide. Oh, sorry, the next slide, apologies. So starting with these protocols, so what's important to keep in mind is, and this comes up a few times in the New York HERO Act, is that the law doesn't mandate that employers do certain things. For example, this first bullet point, it's the New York Department of Labor that is required by the law to create model safety protocols to help prevent the spread of airborne disease in the workplace. Now, under the current law, it's up to the New York Department of Labor to do so within 30 days. This law was signed on May 5th. The effective date for this is June 4th. We're talking about New York State government here. Odds are they're not going to meet that requirement, and we'll get to that with respect to the proposed amendments to this law. So again, the New York Department of Labor, step 1, they need to create these safety standards. Number 2, these safety standards have to be differentiated by industry. Presumably that will mean that your retail store will have a different standard than your restaurant versus your office building, etc. But again, the law itself just mentions that it has to be differentiated by industry. We have not seen any guidance yet exactly how they intend to do so, but we can take probably a cue from the COVID-related guidance that's out right now that was mentioned earlier. there's different guidance for different industries. Presumably, it'll take some type of look to that, some type of differentiation similar to the COVID guidance. These protocols that must be enacted by the Department of Labor have to address a variety of topics, some of which I've included on the screen: your employee health screenings, mask wearing, PPE, social distancing, cleaning and disinfecting protocols, having hygienic, essentially Purell, available, means of employees washing their hands, maintaining hygiene. These are all topics that these protocols must address, again, industry by industry as appropriate. Now, the next bullet is where we get into what's mandated for employers. Employers then will either have to adopt the protocols for their industry that the DOL issued, or they're going to have to create their own disease prevention plan that will meet or otherwise exceed the DOL issued standard for their industry. So either you just adopt the one that's put out by the Department of Labor, or you will have to create your own, again, that at least meets those minimum requirements. That's going to be up to the employer to do. The final part that I just want to mention is that there will be posting and distribution requirements here. That means when employers are going to have to post the plan in the workplace, much like they have to do with other laws and policies, and they'll also have to distribute them to their employees upon hire and after a reopening following a closure due to one of these airborne infectious diseases. I think it's a good point to just pause for a moment and recognize that this is certainly coming out from the COVID environment that we've all been living and working through, but it's going to be applying to diseases above and beyond just COVID. So what exactly, the details for these, what are the trigger points for when these will have to be put in place? We don't know yet. What we could assume is that they will follow close to what the COVID guidance that New York required employers to already adopt for returning to the work. Presumably it will mimic that or look similar to it, but we have not been given any formal guidance on that just yet. Okay, so the next slide will discuss the Workplace Safety Committee. So this is sort of the second big point here. The law requires, and I sort of highlighted here to again make clear what's incumbent upon employers and what isn't. The law requires employers to permit employees to form joint labor management workplace safety committees that will have both employee and employer designees, and there's certain proportions that are required by the law. What I want to highlight is that, because we've gotten this question a few times, the law doesn't say employers have to create these. If the employees have the initiative and desire to create them, employers have to permit that creation. If employees never mention it, never desire to bring it up, there's nothing under the law that requires employers to go out of their way to create these committees. The jurisdiction that these committees will have will be to raise workplace health and safety concerns, review employer policies. Actually, I want to get back to that. Whether it's limited to workplace safety is not 100% clear. Allow these committee members to participate in government site visits relating to workplace health and safety standards. So if the Department of Labor, OSHA, OSHA comes to visit the workplace, then these committee members are going to have to be permitted to attend those site visits. And then number 3 is to permit these committee members to, there's sort of 2 parts here. One is to attend during working hours committee meetings, which are on a quarterly basis, and to attend trainings related to workplace health and safety standards when they're appointed to these committees. There are no limitations on exactly how many hours or how many right now in the law. We'll get to that for the proposed amendments. So that's with respect to the Workplace Safety Committee. So again, we've seen until now the protocols that are going to have to be put into place, the Workplace Safety Committees that employers are going to have to permit employees to form. And then the next slide will be the final sort of piece of the current law, which is what liability exists right now. So what does the law provide for? So number 1 is that there's a non-retaliation provision. So you cannot retaliate against an employee for reporting violations of the employer's standard, that first part of this. Number 2, for reporting concerns of exposure to such diseases. And number 3, refusing to work where, now there's some caveats here, where the employee reasonably believes in good faith, so sort of two caveats, that the workplace exposes them to an unreasonable risk, I guess the third caveat, of exposure, right? So there has to be this good faith belief, and it has to be reasonable from an objective point of view, that there is the risk coming into work. If an employee raises these concerns, they cannot be terminated or otherwise retaliated against as long as it hits those caveats. Number two, to move a little bit more quickly here, number two is that the law authorizes the DOL to issue certain penalties for noncompliance employers. See what's listed here: $50 per day for failing to adopt the relevant standard, or a fine of $1,000 to $10,000 one time for failing to comply with the plan. It also, the law authorizes an employee to bring a lawsuit, a civil lawsuit, seeking injunctive relief to get the employer to stop violating the law. But important with that is the next bullet, which we'll get to specifically for the amendments, proposed amendments, is the fees and liquidated damages. The courts are permitted to enjoin the employer's conduct, so they're allowed to grant the relief, the injunctive relief for failing to comply that the employee sought through their lawsuit, but also award plaintiffs' attorney's fees and costs for having brought the suit. And number two is also to provide liquidated damages up to $20,000 unless, you see the burden here, would then be on the employer to get out of the liquidated damages to demonstrate good faith attempts to comply with the standard. So it's almost a default liquidated damages, almost akin to the FMLA context here in New York, where the default almost is towards granting liquidated damages unless demonstrating good faith. So it's a lot of information. That's where the law stands as of right now. The next slide shows a little bit more about where we are in sort of the potential transitions here. So, Governor Cuomo did sign this law, this act into law on May 5th, about 3 and change weeks ago. So what that means is currently, as of today, the Department of Labor, like we mentioned earlier, has to issue these model protocols by June 4th. The liability provisions, non-retaliation, et cetera, will go into law as of now on June 4th. And the workplace safety committees that employers have to permit employees to form are effective as of November 1st. Those are the current effective dates of the law. But when signing the law, Governor Cuomo also announced that he apparently reached an agreement with the legislature to enact certain amendments to the law, presumably based on the business community's pushback on various provisions of the law. And in the interest of time, I think we'll just skip to the next slide to get to what the proposed amendments say. So these amendments were issued 2 weeks or so afterwards, and after Governor Cuomo signed the law. So a few important points here. And there are some other changes, but these are the most important ones to note. Number one is that the deadline for the DOL to issue the standards if the amendments are adopted, are going to be pushed an additional 30 days. So it'll be 60 days after May 5th, which will take us to July 5th. That will give the DOL those extra 30 days, which they will most likely need. Number two is that the amendments, this wasn't really clear 100%, though logically it was clear. It wasn't clear in the law itself. That employers were allowed to wait until after the DOL enacts their model standards. So the proposed amendments grant employers an additional 30 days once the DOL issues their model industry-specific protocols to then adopt or create their own standards. So that's sort of a clear timeline for employers when they need to act. And it also gives them an additional 30 days after for additional 60 days from when the DOL issues their model protocols for the employers to then provide them to their employees. One of the issues that employers had was sort of the scope of the workplace safety committees, because the language that was in the law, that currently is in the law, I should say, is that they're allowed to review any policy put into place in the workplace that's required by any provision of this chapter, unqualified. So that this law is technically in the New York labor law, so that would apply to a whole host of non-workplace safety sort of policies. So the proposed amendments specifically target that based on the language that I have included here on the slide, and specifically says required by any provision of this chapter relating to occupational safety and health. So sort of narrow that. That was one of the employer's specific concerns that were raised. With respect to damages, some big changes were made here. Number one, currently as the law stands, there is liquidated damages are almost the default for employees to be issued against employers. Now the proposed amendments strike that language, and there's no liquidated damages available under the law, which is a big win for employers. The second part of this is that with respect to attorney's fees, now the court can award under the proposed amendments, the court can award the employer with reasonable attorney fees if the employee's lawsuit was frivolous as determined by a court. So that's, again, another nice piece that was granted based on the business community's pushback. And then just a final note here is the opportunity to cure. The proposed amendments require the employee to give 30 days notice before filing a lawsuit to allow the employer to cure the violation. And then finally, there's a 6-month statute of limitations. So those are the proposed amendments. There's still moving parts. We'll continue to keep everyone updated on it. I do just want to provide the CLE code because I see that we're already at 10 o'clock. So the CLE code, for those who have been asking, is S as in Sam, S as in Sam, 7385. Again, that's S as in Sam, S as in Sam, 7385. And that concludes the more formal part of our presentation. I will turn it back over to Meredith to kick us off for the Q&A section.
Great, thank you. So we have quite a lot of questions in the chat. If we don't get to your question, we will try to reach out to you by email and answer your question following the presentation. But we've picked out a few of the ones that have come in to go over with you all. The first one we got with regard to direct threat. This is for Bob. When substantiating that there is a direct threat for a refusal to be vaccinated, if an employee has been working from home for the last 15 months or so, would there be a reasonable accommodation of allowing the employee to continue working from home? What are the parameters of mandating that people either get vaccinated or come back to the office? I think we're hearing that a lot from some of our clients.
Interesting question. The reality is the following. First of all, if a person is working in a job which is conducive to a work-at-home arrangement, I think it's going to be a little more difficult for an employer to conclude that working from home is not a reasonable accommodation. However, there have been a number of clients who have taken the position that the work from home accommodation was solely due to the exigencies of the issues regarding COVID. And employers do have the right to require employees to report into the workplace. But the work at home issue is going to be there. I don't think we are ever going to get away from work at home accommodations, given the fact that there are a number of employers who are now allowing employees to move to a hybrid approach, working a few days in the office, a few days at home. So it's difficult if an employer adopts that type of approach to be able to conclude that continuous work from home is going to create a hardship. But I think a lot is going to depend on the nature of the job, the nature of the business, how frequently the employee is required to interact with his or her coworkers, the extent of supervision necessary, and all the general issues that we typically face when looking at that accommodation.
Great, thank you. We got another question regarding unionized workforces. Would mandating vaccination for unionized employees need to be negotiated with the union?
My opinion is it probably will be deemed a term, condition, or privilege of employment. It's a safety issue. In the past, safety issues have been deemed to be subjects of mandatory bargaining. A lot will depend on the language in the collective bargaining agreement, whether there's a strong management rights clause and what rights an employer has and what the precedent has been with the union. But given the fact that we now have the Democrats in office and the board is moving towards a Democratic board, I believe the NLRB is going to take the position that that will be a mandatory subject of bargaining.
But balance that with the Democratic push to get everyone vaccinated, right, Bob?
Absolutely. Absolutely.
We have some other great questions for Anne. One question from our newly former colleague, AJ Kaplan. In New York, instead of soliciting vaccine status information or requesting for proof, can an employer communicate something along these lines like, we follow CDC guidance and therefore you must follow social distancing and masking unless you are vaccinated, and then thereby putting the burden on the employees without requiring the employer to collect vaccination status information?
Yeah, so, I mean, I think this is, unfortunately, the answer to a lot of the questions that are going to be coming through today is that it's not entirely clear yet based on the guidance. We have heard from a number of employers who are interested in doing kind of an honor system of, if you walk through our doors, we assume that you are going to comply. I think there's a real open question there of whether the state will consider that an employer who knows that you've been vaccinated and therefore is following CDC guidance versus, you know, putting you in this other bucket that the state's defined, which is businesses who aren't following CDC guidance. I think in the near term, until there's more clarification on that, I would recommend that employers go ahead and, even if you are using the honor system, you know, having that information so that you can say you've collected that information and therefore you can comply with the CDC guidance would be, you know, my recommendation. Obviously, you know, we're hopeful that there will be more clarification on that point.
Another question we got was whether the Florida executive order applies only to employers or does it also apply to customers or both?
Yeah, so the Florida EO was, I'm just looking at my chart here, it very clearly applies to customers at businesses. It is unclear, but it's likely that it does not apply to employers requiring employees to provide proof of vaccination. One thing to note is that it does have a $5,000 violation fine for violating it in place, which is somewhat rare for most of the EOs and the proposed legislation. So, you know, businesses, if you you know, are a business operating with customers, you definitely want to think about that law.
Great. And what about, I think we've been getting this question a lot from clients and employers across the board, is how about separating the vaccinated from the unvaccinated? And what can we do? You know, I think there were something mentioned about bracelets or sections of the office that would be, you know, designated for vaccinated or unvaccinated individuals. You know, what are the privacy, what are the, you know, disability-related concerns that employers should be aware of when making decisions like that?
Bob, that kind of is an overlap between our two sections. Do you want to start?
Yeah, let me start by making the following statement, if I may. There are many employers that are getting hung up on the whole issue of vaccination, no vaccination. And I'm going to throw out a thought. And the thought is for most employers to consider, what is the big issue of continuing the current protocol that most of you have in place? And that is, if you're in an open area, require everyone to wear a mask, whether vaccinated or not. If you're in your office, of course, no need for a mask. If you're in a conference room and you can social distance, no need for a mask. That, frankly, type of approach may obviate the need, frankly, to get involved in segregating your workforce. I've gotten calls and questions from a number of clients about separating people into different sections of the office. And I think that that creates an employee relations nightmare for companies. I just don't see how you can set up two different classes of citizens in the office. Now, some people respond to me when I say that and say, but they have the right to get the vaccination. And I say, yes, they have a right to get the vaccination unless they can't. If they have a legitimate disability or a legitimate religious belief, then frankly, they cannot be vaccinated. So I just don't like the idea of the scarlet letter approach, as I call it, putting, V's on somebody's shirt, putting bracelets on someone's arm. I just don't think it sets up frankly, a employee relations oriented workplace, and it creates dissension and everything else. We're then going to have employees accusing others, why are you not vaccinated? You're putting us, at risk and our families and so on. I just think that there are just too many variables here to get into that. So I'm a strong proponent of continuing the masking and the social distancing and avoiding all those issues. And then, of course, yes, if I'm one of those people who are wearing a mask, will I be subject to questions from my colleagues? Why are you still wearing a mask, Bob? Well, let me tell you, folks, I am vaccinated. I've had both of my doses, and I will continue to wear the mask. And that's just the way I feel until I feel comfortable in my own skin not wearing the mask. So anyway, Ann, you want to add to anything I just said?
I think you covered it. I think one thing that's interesting, we did get a question about, can an employee claim that accommodations are too restricted? For example, requirements to wear PPE in the workplace if they are vaccinated. I think this debate is what is highlighted, and we've seen it, among our own colleagues in terms of, there are workforces where people don't want to wear masks, where their feeling is, I've done this, I'm vaccinated, I no longer want to do this. And that balancing act that employers are going to have to do if they decide to continue to keep policies in place, the pushback that they need to anticipate from certain employees as well. I do think that if you have, a follow-up portion of that question was, can you discipline an employee who refuses to wear a mask or is continually caught not wearing it? I think you absolutely, just like any policy that you have in place in a workplace, if somebody is violating it, you can absolutely discipline the employee for violating that policy, but you need to have the policy in place. And I think that goes back to the question of, if you are going to have a policy where people who are vaccinated don't have to wear masks, you need to know who's vaccinated in order to, know whether or not they're violating the policy.
Right, and moving on to my area of the sick leave, one of the questions we got was whether an order of quarantine is no longer required to qualify for New York State COVID leave. So I mentioned that the guidance published in January clarified that a proof of a positive test is sufficient to qualify for New York State COVID leave, but in the event of a close contact rather than, positive test, then an employer could, in theory, require the employee to obtain an order of quarantine. Although I think many employers are looser with those documentation requirements. And another question I got was whether concerning the overlap between New York State COVID leave and FFCRA. FFCRA is voluntary. It's no longer mandatory for employers. So although that was extended on a voluntary basis, there still is some overlap if the employer has elected to provide New York State COVID leave, but in most cases, there would not be due to the fact that it's no longer mandatory and that New York State COVID leave is much more limited in terms of reasons for use than than FFCRA. And I believe we got another question about whether the New York State sick leave law sort of preempts New York City's Earned Sick Time Act in whole or in part. And the answer is yes and no, because there are areas, there are facets of the New York City Earned Sick Time Act that are more strict than the state law and vice versa. So we need to go with whatever is most employee friendly. With that, it is now 10:15, and we will conclude the Q&A portion of this webinar. We will try to reach out to those who did not have their questions answered, and we thank you all for joining us today.